Hello, everyone. I'm Andy Saldana. I'm the director, executive director, actually, of New York Tech Alliance. New York Tech Alliance is a nonprofit organization that works to create access and connections in the New York Tech ecosystem. We're most known for our monthly event called the New York Tech Meetup that happens once a month at AppNexus, where we showcase amazing technologies to a group of about 300 people and help facilitate those conversation and connections. Welcome to our first event in our new series, The Foundations of Entrepreneurship, and our first event organizing the entity with an amazing panel of experts to help guide you through what company formation options are and answer any of the questions that you might have. Before we get started, I just have a few thank yous, of course, to our sponsors that support the organization and make events like this possible. And just a few quick announcements about what we're doing and the activities that we're up to. Again, thank you to our wonderful roster of annual sponsors. They fund the activities at the Alliance and help us to connect as many people and entrepreneurs to the ecosystem as we can. We have some amazing tools to stay connected, so if you go to any of our events, you can download this networking app called cont'd, and it's a really great way to share resources, your contact information with other attendees very easily. And it's something that we've adopted for all of our events. And then we've launched our new online community called Golden Wheel. And they are a local New York tech startup as well, trying to create a new type of discussion forum. So if you have anything that you're looking for, events that you're promoting, questions that you need to ask, it's a really fantastic place to do that. So we ask that you take advantage of both of these tools and stay connected with us. We have some upcoming events. The first one is next Tuesday. It's our first ever job fair, and we're holding it at AppNexus. We're going to have a great roster of employers that are doing hiring across all disciplines, and we have about over 600 applicants coming through. So it'll be a really, really fantastic event. And then next month in May, we're resuming our regular scheduled meetup. We're doing a very special food tech event. We're going to be concentrating on really cool, amazing food tech, agriculture tech. We'll have some really amazing sponsors that we're announcing in the next week that will be bringing some actual products to the event. So if you have the opportunity, I encourage you to check it out. It's always a really fantastic, fun, collaborative event. Thank you so much to our host, Anchin. I'm going to turn it over to Kris and have him say a few words. Kris, come on up.
Thanks. I'll make it brief. I just want to give a little background on Anchin and myself. So for those of you who don't know Anchin, we're a 350-person accounting firm with experts in various industries. I head up our technology industry practice. Our clients range in size from early-stage startups to the mid-market companies that have been through various rounds of venture capital and private equity funding. Some of the services we perform for our clients: audits, financial statements, tax credits and incentives, the R&D tax credit, which is very popular, entity structure, which you'll hear about tonight, international tax planning, excuse me, and due diligence and forensic accounting. If you want to hear more about what we do, how we can help, I'll be here all night. My colleague Michael Brennan is on the panel, and enjoy the event.
Thank you. And if for whatever reason you don't get either of their contact information, you can always reach out to us, and we're happy to connect you. Next up, also very special thank you to Guest Launch for sponsoring this event and the next one in the series. David Rose, do you want to come up for a few words? Okay, so
So, for those who don't know me, my name is David S. Rose. I've been around here in this Silicon Alley world for probably about the last 30 years. I was in the founding board of the New York Tech Meetup, and I had written the book on how to be an angel investor called Angel Investing. I founded New York Angels here in New York, and my recent book is the Startup Checklist, 25 Steps to a Scalable High-Growth Business, which is sort of the textbook for the kind of stuff you're doing, which is walking through starting up an entire company from ground zero. And what Gus does, Gus is the platform that connects all the world's startups to all the world's investors. We have at this point 750,000 companies on our platform, connecting to 80,000 investors and 3,000 angel groups, venture funds, accelerators, and so on and so forth. And the cool thing we've recently done is to create a new platform called a Company as a Service platform, Gus Launch. And what Gus Launch does is it lets you press a button and spin up a company working with great lawyers. Hopefully some of the folks on our panel will be talking to. These are all friends of ours. By the way, I've known several of these guys for years and years and years. It's a great panel that you're looking at today. And so with Gus, we're not lawyers ourselves. We are a back-end platform that does all the administrative managing, setting up your company. And so I'm going to give you two things. I'll show you what we're doing, and then I'll give you one sentence, the special offer at the end.
Starting and running a company is hard. From the moment you spend money, generate revenue, or incorporate, you'll face legal, financial, and equity management hurdles left and right. Overcoming these challenges means making the right decisions every step of the way. And that can get expensive fast. With Gus Launch, starting and managing your company is easy, cost-effective, and quick. We incorporate your company the right way for investment and growth, and provide a single platform to take care of challenges like issuing stock, opening a corporate bank account, and keeping your board up to date. You'll even get monthly time with a lawyer. Then, as your business grows and you need help with other problems, Gus Launch scales to solve them with add-on packages. When you need to keep financial records, we provide bookkeeping and accounting support, so tax time is a breeze, and you're always investor ready. Need to add team members or raise a round of investment? Soon, Gus Launch will have you covered there too, so that you never have to worry when you make revenue, hire employees, raise funds, or get acquired. Start up confidently with Gus Launch.
And here's the special offer for tonight. On your chairs in front of you is a little package from me with a personally signed note from me. And just for NYTM folks here tonight, if for the end of this week you start your company, because this is the spur to start your company, you can choose for a bunch of things, including big discounts on the service and even a pitch coaching session with me. I'll give you a half-hour session to review your deck and walk through your presentation stuff if you take the high-end thing. So details are in the letter. Hope you'll use Gus Launch. Listen to the panel. These are really smart guys. Thanks, Larry.
David's been a longtime supporter of everything we do and a really great asset, so please take advantage of his offer. And with that, I'm going to turn it over to Paul Ellis, a great partner with New York Tech Alliance, and he's going to moderate the panel. Thank you, Paul.
Thank you, Andy.
You're not going to be able to beat that video.
No, David, you're a tough act to follow, but that's always been the case. To say one thing about David, I was just mentioning to him, when I did my first panel like this, 13 years ago, 2006, David was my first panelist on that panel. So he has been around for a while. He's a great resource in the New York tech community. We appreciate his support. We also, again, appreciate the support of Anchin. We often come and use the space. Anchin is a company that has really great traction and knowledge in the tech space, so you're encouraged to please take advantage of their resources and capabilities as well. So, my name, Paul Ellis. I'm with the Paul Ellis Law Group. I'm also a board member of New York Tech Alliance, and I run the legal events for Tech Alliance. As Andy mentioned, you are here at session 1 of a new series, The Foundations of Entrepreneurship. We are starting at the beginning, organizing the entity, but this is going to be a combination of legal, finance, sales and marketing, and HR and culture. So over the course of a year, we're going to go over the various issues that you need to know in order to start your enterprise, get it off on the right foot. On the legal side, we're starting with organizing the entity. Then next month, we'll be doing a session on how to structure an early stage financing, whether it's angel, venture capital, seed, what have you. We'll talk about the different types of funding and how to put them together. We will be talking next about protecting intellectual property. And then we will have a session on personnel issues, and finally on long-term planning to sell your company. So those are going to be the legal segments, but then of course in addition, as I noted, we'll be doing several on sales and marketing, on HR, and on finance. So I should mention that the legal events, we have been doing these for, as I noted, many years. We have a lot of videos on this series, on other legal topics for early stage companies that we've done through New York Tech Alliance. They're available, are they available on the website these days, Andy? Or?
We're getting to that point, but
okay.
They're on YouTube.
They're not quite available on the website. They're on YouTube. They're also on my firm website. So people may find those of interest. If you would like to get a handout, the slide deck, make sure you leave a business card at the end. You can leave it with me, or you can leave it with whoever, Doug at the front. Also, I maintain a mailing list specifically for legal topics for early stage companies. If you'd like to be on that mailing list, similarly, leave your business card and I will make sure you get onto that list. So with that, we can get into to our session for this evening. I'll say a few words about myself and then we'll hear from the rest of the panel and we'll jump on in. So again, my name is Paul Ellis. My law firm is the Paul Ellis Law Group. We are a 9-lawyer firm here in Midtown. We do a lot of work with small to mid-sized technology companies. We work in areas including formation, financing, intellectual property protection, employment matters, licensing, mergers and acquisitions. All the lawyers in the firm come out of large New York firms and top law schools. So we have big firm training, but with the personalized attention and the more reasonable pricing structure of a small firm. We work with small and mid-sized companies. We work with individual and institutional investors. We work with founders and key employees all around the tech space. Because of the amount of work we do in this space, we can often make referrals to other service providers like accountants, as well as bankers, investment bankers, investors, and the like. That's a little bit about myself. We have a great panel this evening. We have Kris Brown with Goodwin Procter. We have Helen Reeves with Dentons and Michael Brennan with Anchin. And I'll leave it to the three of you to say a few words about yourselves.
Should I go first?
You should go first.
My name is Kris Brown. I'm a partner at Goodwin Procter, just in the New York Times building, not too far away from here. We're a global firm, about 1,000 lawyers, and we really focus on just two areas.
A
little closer.
Yeah.
We exclusively focus on tech and on life sciences. That touches occasionally on other industries like hospitality and real estate, because tech, for example, is permeating all those industries. But unlike many law firms which say focus on just working with startups or just doing IPOs, etc., we do the full life cycle management for companies in those two sectors. And I actually specialize on kind of an evolving, emerging area, which is the convergence of those two sectors. More and more, the drugs and the devices that are used to treat people are involving technology. So drug discovery is occurring on the cloud using artificial intelligence. Medical devices and instruments are being roboticized, and AI is also guiding how that works. So just as an example, I recently helped a client, Johnson & Johnson, team up with Apple to use the ECG, the electrocardiogram feature on the new Apple Watch to help detect atrial fibrillation and optimize the way people are treated for that. So that's kind of what I do, and that's obviously a much later stage deal, but I also work with startups from the very inception until they get to those stages. So that's a quick intro to what I do.
Hi, my name is Helen Reeves. I'm counsel in the venture and technology practice at Dentons. We're also a global practice. We have offices in over 175 countries across the globe. We practice really in all areas. My group focuses on venture and early stage companies, so we work with them through the entire life cycle from, we just started out, we're two founders, what is our equity ownership going to be, to the sale of the business. Not really any industry focus. I'm pretty industry agnostic. I find a founder will walk in and start up a conversation about an area that I have no knowledge of, and suddenly that's a new industry that I'm interested in. But a lot of my clients are in, they're doing data privacy and security. That's a big area. Also, health and life science is a big area, obviously. But again, industry focus, I'm sort of agnostic. I'm more just enjoy working with the early stage founder as they work through the formation issues, the governance issues. I think probably the most interesting issue that I came upon recently was a founder, a solo founder. She actually just was approached by an investor to receive money, and they wanted to do it for common stock. And you would think, oh, that's great, they're not going to be preferred stock, they're not going to sit ahead of her, they're on a similar footing. But it's actually created a lot of interesting issues and problems because a lot of the existing documentation contemplates, sort of preferred stock issuances and the way that works, and how do you create an investor-founder governance structure and financing documents when they're both owning the same class of stock. So it's just interesting issues like that will come up in my practice, and really excited about diving into some of the work we're going to talk about here.
Great. Hello, everybody. I'm Michael Brennan. Thank you for coming tonight. Kris did a great intro. I work closely with Kris in the tech practice. He leads tech practice. I work side by side with him in doing all things tax. Anchin is located in this very building. To add to what Kris mentioned, we actually pride ourselves in being the largest single office accounting firm in the country. All of our brain power and expertise is under one roof in one building. Unlike our competitors where they have satellite offices throughout the country, everybody's here in one building. In addition to tech, I'm also the firm's go-to person for equity compensation, so all things in terms of deferred comp, stock options, restricted stock, phantom equity, 83B, 83I, those things usually come across my desk, and those usually go hand in hand with tech companies, depending on how they're structured and what they're doing. Mostly every tech company, big, small, early stage, well-established, has some type of equity compensation plan for the employees or the founders. So I work closely with our clients to obviously maximize those things and structure and help, obviously work with attorneys and structure those things the best way possible.
I'm going to run through these slides in the first instance, and then I'm going to turn it over to the panel for their observations, war stories, corrections if I get something wrong, or to answer questions. So we're going to try to motor through this and get through a lot of material quickly. So what are we talking about? We're going to start with a couple of quick preliminary considerations for you to think about as far as starting your company. Can you start a company, and when should you start a company? Then we're going to talk about the choice of business entity. Is it going to be LLC or C Corp, or what are the alternatives out there? We will talk about where to organize. Delaware, New York, somewhere else. And then finally, we're going to go through a bunch of other important issues that come up with respect to management, structure, governance, initial funding, and the like. Generally, we are going to be issue spotting. We aren't going to be able to give you all the answers, but we at least want to make sure you're thinking about all the questions. So you know when something comes up that, oh yeah, they mentioned that, and there was an important issue there, and you know to dig into it a little bit deeper. What we are not going to talk about, as I mentioned, we're not going to talk about financing. That's a future session, as is IP, personnel issues, and planning for an acquisition. And then, as I mentioned, future segments outside the legal realm, we'll talk about finance, sales and marketing, and HR. So, preliminary considerations. At the outset, before you start your company, the most important thing to think about is, can you start a company? that which you're trying to do, are you able to do it? Do you own the IP? Do you have any restrictions? And these are really important issues. I'm often have situations where a founder will walk into my office and they'll say, "I got this great idea. I want to get going. Here it is." And we'll start asking some of these questions, and then the answers aren't always the right ones, and that sort of brings us up short. So what are these questions? First of all, do you in fact own the idea? Well, if you're working for someone in this similar space, if you're a university, if you're at a university, you may not own the idea. There may be someone else, another institution that has some rights to it. Is the idea infringing on someone else's intellectual property? If you get past those two questions, are you restricted from competing? Again, based on your employment situation, you may find that you signed a non-compete. Or, to go to the next one, you signed a non-solicit that may prevent your buddy from coming in. I had a client that came in just a couple months ago. It was the golden triple. We hit on all these, we had problems on all these three issues. He was starting a company, but his employer had a potential right to what he was doing. He had signed a non-compete. He wanted to bring his buddy in, and that was a problem. So these are important things to think about at the beginning. You can often sort them out in the beginning, but that's the time to do so. You guys want to add anything here? Kris, you're giving me this long look.
I think that's, you're right on. And especially the obligations, the so-called fiduciary obligations that you may owe to your existing company. You can't take a corporate idea from your current employer and build a business out of it without getting their permission first. And we often see people who start a business taking in investors around an idea, and they're just frustrated with maybe their equity stake because they've been diluted down. They kind of want to start something analogous, and they can face some real trouble from their existing investors or otherwise if they do it without getting cleared first.
The only thing I would add to that is it's not just in the employment context. I mean, sometimes you may be, a student, maybe working on a particular project. I had a couple of clients that are getting their PhD and are doing research, at a lab. Maybe they're also sort of moonlighting, creating their own thing, and they may have signed something with the university that picks up some of their sort of outside work. So just be sort of thoughtful about all the ways in which there might be tie-ins to the work that you're doing, and if there are any agreements that you've signed, making sure that someone's reviewing them for any of these particular traps.
Yeah, one last point here I'd say is, I often say, in these events, time is not your friend. And that comes up in many different contexts, but this is one of them. Right at the beginning of the life of your company, before you start the company, that's the time to address these issues for a couple of reasons. First of all, the company isn't worth that much yet. So your former employer may not feel that they're giving up that much. Second, you may still have some leverage with your former employer. The situation I explained, the client that I had a couple months back, their employer still needed them to close out some projects they were working on. So I said, well, now go back to them and work out a deal. And they may, if they know that they're going to have your attention for a couple months, they may be prepared to cut you a deal on the way out the door. So think about, after 5 years, when your company is the next Google, then it's all over. At that point, your leverage is shot. Your employer knows they've got something to go after, and heaven help us all. So, all right. And that next preliminary, when should you organize the business? Well, there's no rule here, and often people will start their, sitting in there at their dining table coding, and there's no business started, and they're just pounding away at their idea, and that can be okay up to a point. But there are factors that will, that when you hit them, that's going to be the moment to know that you really need to start a business. Some of these are more important than others. I'd say, certainly, if you have a co-founder, that's going to be important. If you want to bring on employees, if you want to enter contracts with third parties, if you're going to bring on financing. The next one, protect yourself from personal liability, tax consequences. all of these are important. Some are more than others. But generally speaking, one way to think about it is when you're starting to interact with someone else with respect to your business, whether it's a co-founder or an employee or an investor or a third-party contractor. When there's another party involved, that's a good time to start thinking about forming an entity.
And also because if you are interacting with third parties, and depending on the nature of your business, you want the advantages of the corporate person sort of shielding you from the exposure beyond just all these other reasons that you would face individually if something goes awry with the business. So the corporation is like a person under the law, and the liability is with that person, that corporation, and not with you individually. So the extent of your exposure, if something goes wrong, unless there's fraud, is your equity stake in that business versus the ability if you just were selling a service out of your home for someone to sue you for your home, your car, whatever you have. So it's important to get something in place right away. I just have one other interesting example, and that is my brother, who's a serial entrepreneur with 3 friends. This is now 8 years ago. Had an idea and filed. 3 of them put their name, filed for a patent, and it. I'll tell you what it is in a minute because it seems so obvious today, but I think back 8 years ago it wasn't. And like 3 years later, this patent issued, and they hadn't really been paying attention to it, but it was a big deal, and they were approached by, you name it, Apple, Facebook, Google, Microsoft, all of them, and there was a massive bidding war, and they ultimately sold it to Facebook right before Facebook went public for an all cash and some stock deal. And because they never bothered to set up a company, guess what? They had to pay ordinary income tax rates on what was paid to them. If they had just merely set up a corporation and at the beginning, they would have reduced their tax exposure by, these days, as much as 25%. But it's a massive amount of money that they just threw away because they didn't spend the $300 to form a company at the time they did this. So I mean, it has a real consequence, and I just make my brother should have reached out to me. I want to kill him still to this day, but this stuff matters.
Yeah, just to add to that, that's a great point I was going to mention. The sooner you establish a company, the better, right? And in Kris's example, qualified small business stock has a timetable to it, right? So you need to hold the stock for 5 years to qualify for the really cool tax provisions that come with it. And a lot of times you'll hear, I was coding in my dining room, when Paul mentioned, and I was working on this thing for 2 or 3 years, and and then when they finally organize something and they go to market, it's a year and boom, somebody wants to buy them. If they did it early and they met that 5-year window, they would qualify for tax-free gain recognition on a lot of it. So, and then anything that's left is taxed at a different rate. So it's a really good point. The earlier, the better.
So again, the mantra, time is not your friend. Kris, that's quite a story.
Oh, yes. Yeah, the technology was location-based advertising. So we take that for granted. And when we walk by a Starbucks or a Target or whatever, it sends us a little notice on our device saying, oh, come in for a coupon or whatever. Like that, ubiquitous today. That was my brother and his 2 friends' idea. And that now is everywhere. And what's the fascinating thing about the IP side of that is that Facebook does own that patent, but in the world of IP amongst the big tech companies, Google owns some other key patent that Facebook uses. They call it kind of mutually assured destruction. They keep these massively important patents in each person's pocket so that they never sue each other. That's really interesting. It's fascinating.
All right, so we're on to choosing the business entity. So the question, which business structure should I choose? There are any number of factors, none of them in and of itself is determinative, but these are the ones that are most important. Tax considerations, how will the business be funded? What is your exit strategy, which to some extent is also related to tax considerations, and generally the business plan and your anticipated operating strategy. I think all of us as lawyers, when we have a client that has this question, what type of business should I form? To some extent, there's some pretty clear answers, but not always. I mean, to really know for sure what the right answer is, you need a crystal ball. you need to be able to peer into the future and know exactly how things are going to go for this company. So to some extent, it's some understanding what their plan is, what their expectations are, make some educated guesses based upon your own professional experience, and guide them as best you can. Should I keep going, or you guys want to say anything at this point? Okay, these are the things we're going to talk about quickly, more than others. Sole proprietorship and general partnership are not really viable solutions, but we're going to explain what they are, if only to make you steer clear of them as best you can, and understand how dangerous they can be. LLCs and corporations are really, especially C Corps, are the ones that are of most interest. S Corps we'll touch on briefly, although you probably will not end up as an S Corp. And then we're going to mention briefly public benefit corporations, which is a relatively recent type of entity, and we'll explain a little bit about that. So, sole proprietorship. If you are that guy or gal sitting at your dining room table, coding and starting your business, and you have not formed an entity, and it is you alone, you are then a sole proprietor. Basically, if one individual owns 100% of a business, which has been not organized as a separate entity, you are a sole proprietorship. Now, again, to some extent, for a limited period of time, that may be okay, but as we've already noted, that can bite you very quickly. There are significant concerns in the sole proprietorship form. As we note in the fourth bullet, you have unlimited personal liability for the debts of the business. You cannot bring investors. You can't award equity to employees. And as Kris notes, there can be very significant tax considerations. So for all of these reasons, while you should understand what a sole proprietorship is and understand how it becomes the default if you aren't doing something else, generally speaking, don't go there. As we note in the last bullet, a single member LLC is so easy and relatively inexpensive to form, you should really plan to protect yourself. Guys, any? Huh?
Full agreement.
Full 100% agreement.
All right.
You don't want to be in this one.
Yeah, don't be here. Don't do this. Partnership, and we really mean general partnership here. Well, so when you at your dining room table has become you and a buddy at your dining room table, or more, so when there's more than one person who is operating this business, but you still have not formed an entity, now you would likely be deemed to be acting as a general partnership. So a general partnership has all of the potential difficulties of a sole proprietorship, but to the power of 10. Because now not only are you responsible for anything that you do, any mistakes that you make, but you're responsible for your buddies as well. So as we note in the fifth bullet here, all partners are personally liable for the partnership's debt or claims. So if you and a couple of your friends are running a business, you have not formed an entity, and something goes wrong, and there is a significant liability, or any liability, against the partnership, any of the partners is fully responsible, personally responsible for that liability. And then to make matters worse, as we note in the next bullet, any of the partners can manage, act for, or bind the partnership. So now any one of you can go out and enter into some really bad deal for the business, which loses a lot of money for the business, and then you personally can be held responsible for the entire loss. So again, don't go there. Don't be that guy or that gal who inadvertently finds himself acting as a general partnership. As we note, your partnerships are pass-through entities for tax purposes. So if you are acting as a general partnership, the profits and losses go directly to your personal taxes. But again, as we note, LLCs are quite easy to form, so that would always be a better choice than a general
I was
partnership.
going to say, maybe in hearing you speak, people would say, well, what the hell do these things even exist for? They sound horrible. And so Paul and I are both certainly old enough to have remembered when the idea of a limited liability company was first created, just like the public benefit corporation has just been invented the last couple of years. So, you know, humans are always innovating, and it's like, geez, like 25 years ago now, and whatever it is that the LLC was invented, essentially. And it has replaced the need for this. But what he just described is why those things existed before, because he's about to talk about a C corporation, and he'll explain the double taxation that it imposes. So that's a bad thing too. And so before we had an alternative to that, which I think I'll explain LLC, these two forms of business, it was sometimes worth all those risks, so you didn't pay twice as much in tax, especially in an era before 1986, et cetera, when the tax rate in America was super duper high. So I just want you to know there's a reason these crazy things invented, but it takes a long time for them to kind of die.
Just want to add one thing. From a tax perspective, when you're looking at a partnership or an LLC versus a corporation, generally speaking, partnerships / LLCs are more complicated with respect to tax compliance. The reason why is because, obviously, as Paul mentioned, the income or loss is going to pass through to the individual members, right? If a partnership or an LLC is operating in multiple states and has profit or loss in multiple states, it may require the individual member to then file in multiple states. If you compare that to a C corporation, a founder, shareholder is just going to get a W-2 if they're performing services for the C corp. Taxes are very simple at that point. So that's just one aspect. The other aspect could be partnership agreements are sometimes written very convoluted and complex. There could be high watermarks, there could be hurdle rates. So generally speaking, and sometimes these things work. So sometimes you want these things in for certain reasons. But if you're trying to keep things simple, you want to keep tax compliance simple, you're probably better off going with the C Corp structure compared to a partnership or an LLC.
Just one point you're making, again, we'll get to it with the LLC, but so for example, that notion of those two people who are just at the table together, and again, without an agreement, say, it's implied they've got a partnership, but if they put in place an agreement, something that's interesting, what you can do with these entities, unlike a corporation, so if you buy stock in a corporation, each of you own 50%, well then if the corporation makes something and you dividend out money, it's 50-50. But with a partnership, you can actually have a disconnect between your equity, if you will, ownership, and how you divide up things like profits and losses. And that can be, again, useful in certain contexts. You know, maybe one person is, you know, for control reasons, they want their equity owned equally, but one person is deriving more value from it. And you can do that in sometimes a more efficient way with these structures. So there, again, there are reasons, but this is all a good setup for why the LLC was.
I should say, we can take some Q&A as we go. So if anyone has questions, we want this to be interactive. So I realized, I thought, God, no one's saying anything. I realized, well, I didn't invite anyone to say I'm not promising we may not cut things off in order to keep on track, but do feel free to ask questions as we go. All right, so now you know about what you want to avoid. So let's talk about LLCs. As Kris noted, the LLC form is about 30 years old. I think it was the late 80s. Wyoming, I think, was the first state to adopt an LLC. But it has very quickly become relatively quickly. 30 years is, I guess it's not a drop in the bucket anymore. When I was a young lawyer, it was a lot more recent. But it's become a very important form for all types of businesses. The LLCs are relatively easy to form. You form them by filing articles of organization or certificate of formation with the appropriate state. As you know from a corporation, the equity holders are called shareholders or stockholders. In an LLC, the equity holders are called members. That's the corresponding term. And an LLC is governed by an operating agreement or an LLC agreement that covers management and operations, allocations of profits and losses, and distributions. There are a lot of important benefits to an LLC, some of which we've already touched on. Like a corporation, but unlike a partnership or a sole proprietorship, members have no personal liability, at least beyond the value of their contribution. That is a very, very significant element, and that alone is a reason to start an LLC. In addition, generally speaking, LLCs have significant flexibility, both in terms of tax and management. On the tax side, an LLC can be taxed. It can be taxed as a corporation, but it can also be taxed as a partnership, as a pass-through entity. So that's an election that can be made. Profits can be allocated irrespective of ownership percentages, which is a very advantageous thing to have. That you're not required to allocate profits and losses, based on the equity ownership, but you can have some other principle for that allocation. More flexibility than a corporation in allocating losses, and potentially favorable treatment on an asset sale. So all of these are the significant tax flexibility in an LLC. Michael, do you want to jump in here?
Yeah, absolutely. Yeah, so I think I mentioned earlier about that qualified small business stock. If you are operating as an LLC and you don't make that check-the-box election to convert yourself to a C corporation, you probably would be walking away from the 1202 benefits. Other considerations you want to take into account are state and city taxes. So for an LLC, if you operate in New York City, there is a tax regime. It's a 4% tax compared to a C corporation or an S corporation, which is more than double. It's at an 8.85% tax rate. Like Paul mentioned, LLCs are very flexible with respect to how you can allocate profits and losses, and that's generally speaking, in my opinion, that's probably the biggest benefit to an LLC from a tax perspective. You can create an agreement, you can provide incentives in the agreement for certain people, and if those incentives are met, you can specially allocate things in accordance with the agreement. You typically cannot do that in a C corporation unless you're going to give a bonus of some sort. So those are some benefits to an LLC from a tax perspective.
Beyond tax,
Someone raise their hand. Questions?
I was just wondering, when you're starting out, you may not have a clear understanding or clear perspective on where the company is going. If you start out as an LLC, then can you transition to take advantage of being an S corp, or you do an election to be an S or a C corp down the road when you realize that your business is changing?
Absolutely, yeah. So it's a fairly simple process. It's called a check-the-box election. You can convert your LLC to a C corporation. There are some things you have to consider with respect to that. Like if you have profits interest partners, and this is again really technical, but for established LLCs that have profits interest partners, you may want to consider how you're going to convert those. Are you going to give them restricted stock or stock options? To the lawyers to weigh in on that, and that could create a dilemma between founders and employees. But that's later on in the life cycle of a company.
The only thing I'd add to that is if you, and I actually like to think of the LLC C corporation, I don't really think of S corporations truly in this context, but LLC to C corp, not as like competing, or it's an evolution oftentimes for a lot of my clients. They'll start out as an LLC, they've got two partners, they're running the business, it's not really generating any income, it's all losses. Those losses get thrown off to the two owners who then report it on their 1040s, and that's just the way that they're operating. And then at some point there's some sort of inflection point where they'll say, okay, we're ready to take on investment, or we want to hire a couple of folks and give them incentive compensation, or there's some triggering moment where they say we're thinking about changing the entity and it makes sense to, and then you can make either check the box election for tax purposes or convert And it's really simple. If it's a Delaware LLC converting to a Delaware corporation, it's literally like one piece of paper that you would then file to convert from the LLC structure to the corporate structure. So you shouldn't, I mean, I think it's really a question of where you are in the life cycle of your business and what makes the most sense. Sometimes, like for example, with one of my clients, they had, two sort of operators and then one person that was really providing sort of the capital, the sort of working capital for the business, and had, just sort of a slush fund of money to put into the business. And they allocated a lot of the losses to that person because they had a lot of taxable income. So it worked out for that, that partner to be in an LLC structure, and it made sense. So it really depends sort of on a case-by-case basis, but I want to emphasize that you can start out as an LLC and certainly convert
And
to
you
a corporation.
cannot go the other way around.
Yeah, that's sort of what, going the other way is not.
Yeah, there are structures and strategies you can employ if you are a C Corp and you want to convert to an LLC. You can drop assets and, but it's more complicated, it's costly, you're going to pay us a lot of money to do that. But, so we say you can't do it because there's a taxable event that occurs if you, convert to it from a C Corp to an LLC. But there are structures that could be employed to do that if need be.
Just two other observations, non-tax, and I'm sorry if I know your hand was up, but just that the certificate of formation is the only publicly filed document. So the LLC agreement is a private document, so no one needs to see that. Whereas with a C corporation, that is something, at least we call the articles or the certificate of incorporation that describes the equity, is actually something that you can publicly view. So some people, that could be an advantage to keep that private for a while. And then the second thing that's interesting, and this is a more recent development, is that the LLCs, you can actually disclaim, I guess is the term, your fiduciary duties that I mentioned, I was kind of alluding to before, these obligations you have to your business. Those can be waived, if you will. Delaware, at least I think under most jurisdictions now, but start with Delaware, and that can be kind of interesting and useful in some respects. So those are two other kind of unique corporate aspects. But go ahead, I'm sorry.
Yeah, I have a question. It's more of a tax question, I think, as opposed to a legal question. There's an LLC with two members. The two members are in different states. The LLC is incorporated in one state. So what is the tax implication for the entity or
It's
for
most of the time, it's a frequently, we can get into the reasons, but like people live in Nevada and California, but they'll have a Delaware LLC. So it's very common to have the entity be from a completely different state from where the individuals are. And that has to do, the tax treatment of them all is the same, but that has to do with the kind of sophistication of how the law has developed around managing. And these are, companies are run by state, not federal law.
Right.
So every state has a different, and that's why Delaware, this little tiny state, like everyone was like, why Delaware? It's because they just were smart early on and made it easy and cheap to go there, and the case law developed, and it's very user friendly, and it's very certain what happens. Like, I'm from Alaska. The heck, there's probably an Alaskan corporation. Who the hell knows what would happen in that?
So what case law in Alaska?
So so to answer your question, the tax treatment is the same, it doesn't matter. What you do have to do if you set the Delaware LLC and you're operating in like Nevada and California, you do have to have doing business in those states, filing relatively cheap to put in place.
I just had a follow on. The LLC is in California, but the members are in California and New York. So
It's really about where the business is
Yeah,
operating.
right. So where it's taxable is based on nexus, and that's where you're operating. And there's other things that go into nexus as well, but generally speaking, it's where you're operating. From a tax compliance perspective, like where do I have to file tax forms? Certain states require that if you have a member or a partner that resides in a state, New Jersey, New York is a few of them, you're required to file a tax return in that state regardless of if you have nexus or not, because you have to, there's certain state adjustments that would flow through on an information report that a member would get. So I think that answers your question, right?
Yeah.
Okay.
All right, so the last bullet here, moving off of the tax issues, LLC also has a lot of flexibility in terms of management. It can be managed by the member directly. We call that a member-managed LLC or members. The members can appoint managers to manage it. There can be a board of managers akin to a board of directors in the corporate context. And then that board of managers can even appoint officers, so you can really mimic the corporate management structure at one end, or simply have it member managed at the other end. Drawbacks. Well, same as with a corporation, there is the personal liability limit can be lost if you, pierce the corporate veil. That's, as long as you run the company correctly, follow corporate formalities, you capitalize it properly, and you don't mingle the accounts. That should not. You don't commit fraud. That should not be a problem, but that should be noted. All 50 states have different LLC legislation, so although they exist in all states, the rules are different. We'll talk a little bit more about that. As I think we noted, incentive compensation schemes can be more difficult. So for example, you cannot give incentive stock options, which are tax advantageous equity scheme. That you cannot have that in an LLC, although you can in a C Corp. Very important point. Investors, venture capital investors and offshore investors generally will not want to or be able to invest into an LLC. That's one of the biggest hits against LLCs. But as Helen notes, very often we will start early stage tech companies as LLCs. When they come time to bring in investors, they'll simply convert it. But that is something to be aware of. If you know you're bringing in a venture investor in the next couple of months, well, that probably isn't worth the trouble, and you should just start right away as a C Corp.
Maybe just explain, it has to do with the pass-through nature. Many of the, like pension funds and other investors, most venture capital funds are comprised themselves of tax-free entities like universities and endowments and others, and those guys can't directly have operating income or losses get passed freely back up to them. So the double taxation that a company has, corporation has, C corporation, blocks that from ever coming back up to those entities. There's, it's like voodoo to them, and that's why you have to typically create a C corporation before you take on venture capital and other money. And the other thing is a pure optics thing. I mean, companies, if they ever go public, it's theoretically possible to take an LLC public. I'm not aware of anyone ever. And so there's just, again, kind of like the Delaware example I use, there's just sort of an understanding of how you would let a company, corporation go public, and therefore no one knows how to do it with an LLC, and you just go with what's easier. So again, you turn into a corporation before you, a C corp before you go public.
Paul, I just want to make one point about corporate formalities, because we sort of, it's an important point and I want to underscore it. There's a lot of early stage clients I've had run up against this. So what does it mean by corporate formalities? So you form an LLC, maybe you don't set up a bank account, maybe you're just pulling money from your own bank account and putting it into that bank account, or vice versa. You're signing agreements, maybe you're memorializing the decision to sign those agreements, maybe you're not. At some point, you sort of tip over and risk the limitation of liability protection that LLC gives you when you don't treat the LLC as its own separate corporate entity. So what does that mean? That means when you set up a bank account, you have to document, if you're making a loan to the business, document that as a loan. Have a promissory note that establishes that on this date, for this amount of money with this interest rate, I loaned this money to the company. Don't just sort of have money swapped in between accounts, because the risk is if someone sues the company, they can say, well, there really wasn't a company, right? It was just basically, it's you, because the bank accounts are sort of fungible, money was flowing in. The most typical example is typically the fungibility of money between accounts. There was no documentation of sort of how decisions are being made and this is even if it's just you as a solo founder. You want to document all corporate decisions, hiring of people, you want to have clear, offer letters and things in place. I've seen this happen, and it's been quite ugly because you think you're setting up a protection for yourself, and you've basically nullified it by conducting business as if there is no separate legal entity. So you want to respect that process in order to maintain that protection.
Absolutely. One question, yeah?
I was wondering if you could elaborate a little more on why LLCs aren't appropriate for offshore investors. Are there tax implications, or what was the reason behind that?
Yeah. So if there's profit from an LLC to an offshore investor, the LLC would be required to withhold taxes at the top tax rate based on that foreign investor's shared profits remitted to the government. And then if that foreign investor wants to get that money back, they have to file a U.S. tax return, claim the income and the withholding.
Yeah, so it exposes them to having to make tax filings in the U.S.,
So
which
the
they don't want to.
shareholders,
The
so if it's a foreign corporation that owned a US-based LLC, then potentially the shareholders would have to?
No,
Not the shareholders.
the vehicle that owns a membership in the LLC. So if it's a foreign corporation, the foreign corporation would have withholding remitted on its behalf from the partnership and be required to file if they want to claim that money back.
And if they're operating outside the United States, no one wants to go through that hassle because it potentially exposes them to all sorts of other reporting of their operations globally to the U.S. government.
Yeah.
All right, so to finish up on this slide, a couple of other points to note. LLCs formed or operating in New York have to meet the dreaded New York publication requirement, which many of us are familiar with. That's when your local newspapers take between $1,000 and $2,000 out of your pocket.
It's total old school bribery or something.
It's
extortion.
Yes, so the legislature is in the pocket of their local newspapers, so we live with it. But basically, we're laughing about it because it comes up all the time. But there's a requirement in New York State, and I think only 2 other states in the country. When you form an LLC, you have to publish a notice of the formation of the LLC in 2 local newspapers once a week for 6 weeks. And depending on what county you're in, that can be anywhere between $500 and $2,000. So it's a really costly requirement, but there's not much to be done about it. And then lastly, the documentation for an LLC can be more complex. Whenever you want to do something with an LLC, make a change in an LLC, generally, as corporate lawyers, first thing we do is we pick up the phone and talk to our tax colleagues because there are tax ramifications to a lot of the work changes we make in LLCs just because of the complications of partnership tax. So that's just, there are more complications in an LLC tax-wise than in a C Corp. All right, let's talk about.
Just a question on the publication. Do you have to announce in the local area where the company is established? Like, if I was to, publish or put in an ad in a newspaper in upstate New York, probably be a little bit cheaper than putting an ad in to a, New York City type of publication. Does it matter where you publish your announcement?
I don't think it does.
Well, I mean, it has to be, let me jump in on this. It has to be the county where your principal office is located. Yeah. And there's a dodge that people, I wasn't going to go here, but there's a dodge that people often do. You form your entity in, somewhere way up north or out west where you can publish for $500. You form and you publish there, and then you change your address to your local address. You can save yourself, $1,000 doing that. So, there is a way to. I don't recommend that be done, but I have heard of people. I've heard of people doing that. So, that's the answer to that.
It's usually those secure newspapers like the Irish Times of the Bronx or something.
It's a revenue generating scheme, that is. I mean, that's what it is.
If you don't publish? Well, technically, there is no penalty written into the law for failing to publish, except that you will not be able to appear in court to bring an action or defend an action in a New York court as long as you have not complied with the publication requirement. However, once an action has been brought against you, or if you wish to bring an action, you can publish retroactively. I mean, I don't know what your experience is. On several occasions, people have come to me in that situation, and we've been able to publish retroactively, and they can represent themselves. It doesn't seem to be a problem. I am not aware of anyone ever being penalized for not having published, and there is no penalty written into the law except the one that I just mentioned. You guys
It's the
wanna-
same. That's my experience too.
I have a question actually for you guys. Would there be a reason why you would have an LLC created in New York versus Delaware? Like, why wouldn't you just create a Delaware LLC and then register it in New York? To avoid this whole publishing.
It doesn't
I get this
avoid-
question
doesn't
often.
No, no, no. If you're it doesn't avoid any stuff.
When you qualify the entity in New York, then you have to publish.
When you register to do business in New York.
Yeah.
it's published.
You have to pay. It's actually.
They know.
But that's a good question as to why you would ever choose a New York LLC over a Delaware LLC. That's
And
political.
we will get there.
The reason is because you can convert. No, I have the answer. The reason is you can convert a Delaware LLC to a Delaware corporation way more easily
is true.
than
This is
New
true.
York LLC to
Again.
Delaware. So if you think that you're going to move from LLC to a corporation, form it as a Delaware LLC.
Well, no, we're on a line. I said,
Yeah.
why would you ever start in New York?
Oh, yeah, no.
Yeah, no,
Yeah,
all
no
of
way.
the considerations for jurisdiction apply to LLC as corporations. And we will get there, at least I hope we will. Okay, we're going to talk about corporations. Like an LLC, a corporation is a separate legal entity, also with limited liability, and is distinct from its equity holders, in this instance called stockholders, as well as directors and officers who manage and run the entity. All states have corporation laws. They often differ a little bit, but not by much. Although we will talk about the difference between Delaware and many other states. You form a corporation similarly as forming an LLC. We talked about the nomenclature. Stockholders or shareholders is the nomenclature for equity holders. And corporations, unlike the flexibility of an LLC, corporations are much more fixed in their structure. They are managed by a board of director and officers that are designated by the board of directors. Benefits. As we noted, C corporations are separately taxable entities, and so you have a two-level of taxation. Now, that's both a benefit and a drawback, depending on the situation. But for the reasons we were talking about, it's a benefit. It's a benefit to your venture investors. It's a benefit to your offshore investors. The limitation of liability, we talked about that. We talked about the fact that Delaware C Corps are familiar to and favored by professional investors, and frankly, VC investors will generally only invest into a Delaware C Corp. And we also talked about the fact that salary and incentive compensation simpler to implement. Again, ISOs you can do with a C Corp, you cannot do with an LLC. Drawbacks, again, two levels of taxation, limited flexibility in management, and you do have corporate formalities that cannot be avoided. Annual meetings of shareholders and directors and the like, which you do not necessarily need to have in your LLC operating agreement. Guys, you want to jump in?
From a tax perspective, some of the benefits under the new tax law are C Corps are now subject to a 21% flat tax rate, right? Compared to an LLC, top tax rate for an LLC member is 37%. And state taxes are also deductible under a C Corp structure. If you're an LLC and you get income passed to you as a member, your state income taxes are now capped at $10,000. So there are some benefits for a company that's a C Corp that's looking to keep the profit in the C Corp and not pull the money out, because if you pull the money out, that's where that double taxation occurs. So there are more benefits now if you're profitable and you're a C Corp based on tax rates.
I want to emphasize a point that you just made. One of the drawbacks listed here is two levels of taxation, and that's often brought up as the key defining sort of difference between the LLC and the C Corp. The reality is, though, for most early stage companies, there aren't two levels of tax because you're not dividending out any money to your stockholders, right? So the two levels of tax comes in first at the corporate level. So say you're running a business and you generate $100 worth of cash and you've got to pay taxes on that. And the taxes, I'm just going to make it up, whatever, it's $10, make it up. You can, as an entity, pay the taxes owed, right? And that would be that. But then if you dividend out any additional cash, anyone who receives that cash also has to pay tax on the cash they've received. So that's where the double taxation comes in. But if you never pay a dividend, there's no double tax.
Well, but it's also double taxation to the extent, you know, the individuals working are employees,
Right.
so they have to pay
Pay
tax, so not just
taxes.
through dividends. So again, with an LLC, in theory, you know, you could take
Well-
profits. In theory, you could just. There aren't profits for any of these
Right,
companies at this
right.
stage.
At
but
this
you
stage,
can-
there's no. I mean, I like to emphasize to clients that sometimes the emphasis on the two levels of taxation, I think, can be sometimes overstated because for the kinds of companies we're talking about, you're not paying out a dividend. So at least tax at that level,
Yeah.
there really isn't.
Yep.
I see a question over there.
Can I ask a quick question?
Yeah.
So what happens if, like, you know, your starting team each puts in, say, $20,000 each to your C Corp, and then, you know, those first 6 months, you're bringing in, like, very small amounts of revenue, and you're basically paying yourself income with the money that you just put in to your company, but now you're paying taxes on money that you've already paid taxes on before.
Yes, you are.
Yes, you are.
Like, is there
Why are
any
you doing
way
that?
to-
Because you're owning the equity and hoping by running the
Exactly.
business, the equity itself will appreciate in value well beyond, and that will only be taxed if you've done it properly at a very low rate down the
Yeah.
road and versus the salary you're taking. So it is, you're optimizing ultimately the value of being in business by setting it up, but there are those costs, and you're absolutely right that you're using post-tax dollars into a company, and if you happen to use it to pay yourself, you're paying taxes again. It all seems ridiculous, but those efforts are creating value and attracting investors. So that thing which you guys or gals put, you know, $40,000 into 100% of it, if you make it sexy enough, you know, an investor comes along and gives you $1 million for 10% of that, and you now on paper, as the remaining 90% implied value, you know, $1 million for 10%, both of you are now, you have $4.5 million worth of value, you know, on paper, that if it was to be sold, you'd pay again after a year and blah, 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 very 21% versus, or less, versus 37%. So that's the game. You know, that's what we're doing.
Just to add to what Kris said, I wouldn't advise somebody, if they're putting their own money in, to pay themselves a wage out of a C Corp.
Yes.
Just would, you would not do that. When you raise money and you have other people's money, then you pay yourself a wage.
Exactly.
So
That's-
never, ever put money into a C corporation and then turn around and pay yourself a wage. Pay other people a wage because you need
Typically,
people.
you won't have the money to do that, let's be honest. I mean, again, I take it from a practical perspective. At a very early stage, you're bootstrapping. You're putting money into this thing. You're not paying yourself a salary. I mean, you're not going to have a salary until, at a minimum, the company is generating enough revenue to support itself, where you don't have to keep putting money into it, right? So practically speaking, some of these questions don't become really relevant or salient until you get to a different stage of company, and not the formation stage, but it's a fair question.
All right, so we're gonna, I'm sorry, we gotta keep moving. I'm gonna say, take a minute to talk about S corporations, but I don't want to spend long on it. An S corporation is a corporation that's treated as a pass-through entity. We don't really use them that much anymore for early stage companies because LLCs really are, you know, generally a better bet. And then, as Helen said, maybe converting into a C Corp. But it's a corporation that can have pass-through treatment, so you avoid the two levels of taxation. The problem with S Corps is there are a lot of limitations on them. As we note in the third bullet, income has to be allocated in accordance with ownership. And then in the fourth bullet, only U.S. citizens or residents as stockholders, only one class of stock, so you can't give preferred stock to investors. Stockholders must be individuals, and you have a maximum of 100 stockholders. That's a lot of limitations. I mean, basically, you can't bring in investors, you can't get preferred equity. There are a lot of limitations on escort. I won't say they don't get used, but they don't get used that much compared to the other areas. Okay. And a word on benefit corporations. A relatively recent animal on the scene for those who are looking for a way to pursue a public purpose as well as pursuing profit. Not all the states recognize them, but well over half of the states have public benefit laws. The Delaware public benefit law is really the gold standard in this area. Distinguishing features from traditional corporations: has to commit to a public benefit, must consider the interest of constituencies other than its shareholders, it must report on its social and environmental performance, and shareholders can enforce the public benefit mission. So it's certainly not the right answer for everyone, but if you are thinking about a business which would have a public benefit as well as a profit motive, it's certainly something to consider.
Do you have an example between a charity and a company?
Was there a question?
Do you have an example of benefit?
Yeah, I have one that I work with. It's a company spun out of Boston University, and it involves essentially a technology to build an artificial pancreas. It's sort of a combination algorithm and a insulin pump along with what's called glucagon sugar pump. And the thinking is that, and they have investors. They have somewhere like like Medtronic is an investor, for example, and I believe Lilly is an investor. So people looking to make money. This is a big, diabetes is a massive market. But at the same time, they want to not just be driven solely by profit, because they don't want it just to be solely like to seek the highest reimbursement levels, et cetera. They want this to be accessible to the masses who suffer from diabetes. So they don't want to be in trouble if they make some decisions that are to, say, go for markets where they won't be maximizing profits, say to go to Africa to try to get this product put in place. You know, literally people have to maximizing shareholder value means going, that's why maybe the US is the massive market. The reimbursement levels are highest here, et cetera. Those are all great things, but aren't necessarily benefiting the world. So there are plenty of ways to make money without being subject to literally a lawsuit from your shareholders saying, well, why are you in, sub-Saharan Africa versus, New York City or whatever it is. And so it's an interesting new phenomenon.
Can I just add one thing to that?
Of course.
There's sort of two animals out there, and I want to make sure people don't get them confused. So there's actually an entity, and I forget the name, but they actually provide like a certification that sort of stamps you as
Like
a
an
B
ISO.
Corp. Yeah, like a B Corp, where they say, we've looked at your business, we've looked at what you're doing, it's mission driven, we think you're great, and we're going to give you this certificate that says you're a B Corporation. That is not the same thing as being a benefit corporation. A benefit corporation actually has language baked into its charter that picks up a lot of the stuff that Paul mentioned, meaning that we're going to look to other constituencies like our employees, like the environment, like the neighborhood where our plant is built. We're going to think about what's best for them in addition to what's best for our stockholders. That's a very different and I think a much higher standard when you bake it into your formation documents, that these are the constituencies you're going to help, as opposed to just sort of getting like a nice shiny gold sticker and a certificate. Not to say that that's not important and a good thing, but I just want to make sure people know that some corporations are calling themselves B corporations and they might be in one or the other bucket.
All right. Sorry to be the guy who has to keep pushing forward. I'm the one who knows how many slides we have. Okay, so where do you organize? Well, you can organize your LLC or your corporation in any of the 50 states. You don't need to be doing business there, but you do need to be qualified in any business where you are doing business. What are the relevant considerations? Well, organizational fees, franchise taxes, and other requirements like publication. How investors are going to feel about the state that you're organized in. Predictability, this is an important one. The state of the corporate law or LLC law in that jurisdiction, whether it is kept current and how the courts interpret it, the geographical location of the business, the corporate income tax rate, and there can be specific state law issues. So all of these theoretically play into your decision about what state you may want to organize in. Popular states for organization are first and foremost, head and shoulders above all the rest, is Delaware. New York is a respectable choice as well, but not nearly as popular as Delaware. And then you could consider the home state, which is generally not, if you're a go-go early stage startup company, generally you're not going to go with your home state unless your home state happens to be California. If your home state is California, that may be a situation where you may end up organizing in California. But generally speaking, Delaware is the, we'll get on to specifics about Delaware and New York in a minute, but Delaware is certainly the most popular. But you do need to be aware of wherever you are organized, you are, the applicable laws of the states where you are conducting business apply to you. You can be sued in these jurisdictions, and you are liable for taxes in the jurisdictions where you are doing business. Should I go into Delaware? Or you guys? Delaware. So definitely the preferred state of incorporation for tech startups. We have now talked about, we talked about how investors look to the corporate form over the LLC. For other reasons, investors often will generally prefer that you are incorporated in Delaware versus any of the other states. There are many reasons for this. As we note in the next bullet, well-developed body of corporate case law. So Delaware has a very thorough case law, both on corporations, on LLCs, business forms. It's kept up to date, it's kept current as there are developments in the law, such as the benefit corporation we just talked about. Delaware has the gold standard in public benefit laws. So Delaware prides itself and makes a point of keeping at the cutting edge of developments in the legal field in corporations, LLCs, and other business structures.
It was even the first jurisdiction last year, 2 years ago, to employ the blockchain to let you keep track of your corporate books and records. I mean, they really try to be ahead of the curve. It makes sense, right? Because if anyone knows what blockchain is, it lets you uniquely identify intangible things. So a stock certificate is kind of this intangible. Why should it be a piece of paper? You own it. Wouldn't it be easier if you could just have it up there in the ethos and sell it to someone, not have to physically send it? And so they were the first to just say, hey, let's use this new technology. So they're just way ahead of everyone all the time.
Go ahead.
Is there a little bit of a caveat or restriction if business that you're working with is a medical business where you're dealing with physicians and, does that relate
No.
to any of these considerations? No.
Not at all.
Similarly, the court system in Delaware is also very experienced in dealing with corporate disputes. And many questions under corporate and LLC law have been answered in Delaware that have not necessarily been answered in other jurisdictions. So if you come to us, your lawyers, and say, well, I want to do this, is that okay? It's more likely that we can go to Delaware and find an answer. Yes, you can, or no, you can't, because here's the case law on it. That question may not have been considered in New York or Nebraska. Not against Nebraska, but you understand.
Use Alaska.
Alaska. Filing services are also very efficient. And things like that matter. When you're a big financing or an acquisition or something, it really matters that the filing service is going to be open and get that filing done timely. You've got a lot riding on it. And then we just follow with some statistics about how many entities are in Delaware.
And importantly, lawyers and accountants, they don't have to be based in Delaware to be able to advise on all these issues. So just that, you know, I don't have to be admitted to the Delaware bar in order to have all my clients be Delaware corporations.
Yeah, and frankly, you know, I'm a New York lawyer, but there are a lot more questions I can answer for you off the top of my head under Delaware law than under New York law, just because that's what we're dealing with every day. You know, we just, you know, most New York lawyers probably know much more about, who deal with tech startups at least, know a lot more, you know, Delaware law off the top of their head than New York law. Having said that, we'll talk about New York. If your business is really a New York-based business, then you should consider New York. It's certainly a good second choice in Delaware, you know, to some extent. It's a home state for many professional investors. Often we will find commercial contracts will be governed by New York law. So although corporate governance documents will be under Delaware, but commercial agreements are more likely to be under New York law. But at the end of the day, as I note in the fourth bullet, New York is just not nearly as widely used as Delaware, especially for tech startups. And then we note again, come back to that publication requirement. Anything else on this one, guys? And then finally, home state. If you're really in, if your business is in some state that you're not likely to be looking for investors, then maybe that state may make sense. If your business is related to real estate, there may be reasons to be in the state where you're doing business. There are some reasons that it makes sense for your home state, but for the sorts of issues we're talking about in this room, generally it's going to be, Delaware is going to be your choice.
What about the liability for large equity holders, personal liability for wages and other matters under New York law?
So you're talking about the 10 shareholder rule, that under New York law, the 10 largest shareholders of a corporation and 10 largest equity holders of a LLC are responsible for the unpaid wages of the employees. Yes, that is just one more reason to be in Delaware.
Although that concept exists in other states too, California and other jurisdictions.
Right. I mean that's not everywhere, but that's an example of a state a characteristic under state law that you need to be aware of that may push you in one direction or another. All right, so we go to governance, ownership, and other considerations. We've really talked through these. These are the things you need to think about for your corporation. Name, classes of stock, capital contributions, composition of the board and control, stockholder and board voting requirements, title and identities of officers. These are, for an LLC or for a corporation, when you form, these are the critical factors that you need to think about. We're going to go into these in more detail in the next few slides. For an LLC, same thing, name, contributions of membership interest allocation. We talk about tax allocations and distribution to members. Need not be pro rata. Management governance. So regardless of what type of entity you have, these are the fundamental issues that need to be picked up in your organizational documents. For a LLC, it's going to be your operating agreement. For your corporation, it's going to be your charter, your bylaws, and probably a shareholder's agreement.
Hey, Paul, maybe one thing to mention is that with a corporation, you actually have to technically have stock certificates that are given out to people to show their ownership, and that really, those are, call them negotiable instruments. They have value just sitting there, and but you can have uncertificated membership interest in LLC. So there is sort of an advantage, again, to the LLC that you don't have to go through that formality of having this, one of the stock certificates, these pretty colorful piece of paper that shows your ownership.
Yeah, generally speaking, yes, there are fewer formalities with LLCs. Yes.
Quick question. Is it important to have an initial capital contribution for an LLC all the time?
For any company.
Yes, yes.
Establishes your basis.
I want to emphasize this, yes, yes. I have a lot of clients that do not memorialize that, and then particularly for LLCs, just given the complexity, their accounts will say, well, what are the capital accounts? And your capital account is established, at least when you first form the company, by your capital contributions, and then allocations of profit and loss will affect that capital account, positively or negatively. And I've had clients who come to me, they've got an LLC that's been in existence for 2 or 3 years, and they have not kept track of who's put money in when and where and how much, and it can really create a nightmare. So yes, particularly for LLCs, but also of course for corporate entities.
Typical situation I'm faced with this startup is that they've had this idea for a while, but they don't want to spend the $800 or whatever it takes to set up the company, okay? They have this whole idea of what they should own, but they decide to only do it when they've received a term sheet from a VC fund that wants to give them $1 million for 10% of their company. So let's just think through what that means. They haven't actually paid $5 to own each, or 20,000, but some de minimis amount to have set up the company in the first place. Instead, they think they're going to get that stock at the exact same time that person's putting $1 million. Even if that person, I won't get into the complexity of they're putting in preferred stock versus common, because a nuance is there can be a discount ascribed to the common stock versus the preferred, because the preferred it's preferred, it's got more protections, etc. But that discount, as you would attest, can't be much more aggressively, like a 60% discount at most. In the old days we tried for 90%, but say there could be a discount. You walk into that and you think you're going to own, in your example, like now 45% of this company, and you're given that stock right then. The IRS will view that as you having received a new car worth $4.5 million. That new car comes in the shape of a piece of paper, that stock certificate, but that's how the IRS views it, and they come in April of the next year, want to know, that's a really expensive piece of paper you're just given, and by the way, you got it, and it looks like compensatory almost. Where's my 37% of that in cash, cold cash right now? And you're like, what? So it's really important that you immediately put the minimum amount, establish your ownership, and then everything else, again, is just appreciation, and no one's going to question it. And we haven't gotten into all the 83Bs, but there are all sorts of really important things that go into for planning and not being hit with this horrendous. And by the way, so that happens all the time. But nonetheless, it happens, and what that does is it pisses off the investors, because they've then got 2 disgruntled shareholders who have this huge obligation of the IRS, yet their idea is really cool. So money has to be spent to kind of help them pay those taxes instead of going to the business. It's all a frickin' mess. So, it's really important to do. Good question.
All right, we're going to go on to the next slide. So, we talk about governance and transfer considerations. So these are all the things you need to think about in the organizational documents for your entity. And we're talking generally here about where there's more than one founder. That's where this all comes up. Vesting or reverse vesting, really important concept. When you have more than one founder, the question is, are these guys going to get their equity 100% up front with no obligation to give it back under any circumstances? Or if one of them were to leave after 6 months, or to not pull their weight in the business, are there some conditions, some terms on which they would have to give back their equity? This will virtually always come up when you have sophisticated investors in the mix. The question is, when you're forming the entity and it's just you and a couple of friends, should you still put in reverse vesting provisions? I strongly counsel my clients that they do so, because otherwise you may find yourself in a situation where you and a friend start this business, you work together on a year, full tilt, and then your buddy goes off and says they lose interest and go off to do something else. You want to keep building this business, which is a really cool idea, but they own 50% of it. And so they own 50% of the business that you're going to continue to build. So people, go back and forth, say, do we really want it? But you need to see it from both sides. If you're the person who stays, the person who goes, is it fair, does it make sense?
And also, in that example, it's often, one way I kind of convince people to put it in place beyond that is an excellent reason, because everyone, right, when they start a business, oh yeah, we're best friends. It's just like when you get married, you're massively in love, and yet people get divorced, So another convincing argument I use to tell people to do it is that if you put in place a reasonable vesting scheme now, when the investors come along and they would otherwise impose it, they're going to stick with what you have versus imposing a much more aggressive potential vesting. Like if you put yourself, say 2 years vesting every month or quarter, they're not going to mess with that. Whereas if there's no vesting and that guy comes along with $1 million, he or she's going to say, yeah, I'm going to give you that, but I want you to be vesting over 4 years, meaning they're really going to have you, that equity, you really have to be with that business for a long time before you own all the stock, because that's more what's market. So you set the precedent, and then it's harder to challenge later.
I'm just going to say two things. There are very few things when it comes to startups and early stage that I'm sort of hardlined about. Vesting is one of those things that I'm hardlined about. Put a vesting schedule in place. If there's more than one founder, I can't think of a reason why you wouldn't have a vesting schedule in place, some sort of reasonable vesting schedule. I mean, the typical one I see, again, is the 4-year vest, 1-year cliff, 25% vests after the first year, and then the balance vests over 3 years monthly. That's the very typical vesting schedule. I think if you put that in place when you start, most investors will see that, they'll do the math, they'll respect it, maybe they'll cut back a little bit, but at the end of the day, there's zero reason not to put a vesting schedule in place. Everyone should be fully all into the business. You're getting your equity for your sweat, right? You're getting your equity because you're going to put value and time, and you're going to sweat it out to get this business where it is. If you decide you don't want to sweat it out to get the business where it needs to be, then you shouldn't keep your equity, right? I mean, it's as simple as that. And I've seen many a business fail because of this one issue. They don't set it up at the beginning. Everyone owns it a third, or 50-50, or 25%. Then you've got this one guy sitting out there owning a quarter or a third of your business, doing absolutely nothing. And he's sitting on your cap table. You raise money each time. It really is a huge problem. So there are very few things I'm hard-nosed about. This is one of those things that I'm hard-nosed about.
And mechanically, it can be set up, so again, at the beginning you put a de minimis amount, say the third, each of them put in $100, and to own one third of this. And so, say the vesting is imposed right away or later, you basically, how it works is the company has the right to acquire back, repurchase the stock, and this can be negotiated. Typically it's at, the same price you put in, or sometimes, say after a year, it's at a third-party appraised value, or it's at a negotiated, 10% return off of your original. It can be done in a myriad of ways, but it's much cheaper to do it then or under that scenario than it would be based upon the actual value of the business down the road. So that's what's important. And a little mechanic, and again, to make it be effective, you have to make within 30 days of imposing this vesting what's called an 83B election with the IRS, and it's required that you mail this in within 30 days of the vesting being imposed, so that you ultimately have the optimal tax treatment around it.
Yeah. So if you just real quick on 83B, if you have two founders and they impose a vesting schedule, and let's say it's a 4-year vesting and it's $100, a very, very small value, you 83B it, and you're basically starting your tax clock at that point, right? So you may recognize income of, let's say, $100 each. When that stock starts to vest, it's not going to become compensation to you because you made the 83B election. If you don't make the 83B election and the stock starts to vest over time and there's different values, people come in and invest, or you get an independent appraisal, it will be then become compensation to you as it vests. So it is, I can't emphasize enough, if you do impose a vesting schedule, which I totally agree you should also make the 83B election, and it needs to be mailed to the IRS within 30 days of your receipt of that stock, basically.
And you do a return receipt requested, so you have a record of this thing being received by the IRS, and just keep it in your file. And again, I just want to kind of explain, because sometimes it's complicated to understand, that to his point, if you don't do this, 6 months go by and your first vesting occurs, yet the company's gone up in appreciating value by 100%. Again, all you have is this piece of paper. You have no liquidity because there's a paper value, yet the IRS says there's value and they ask for cash from you. And that's crazy, right? So who wants to be in that position?
All right.
Is this
I think we're gonna have to, I'm sorry, we'll be around afterwards.
This is so important.
Yeah, this is like
This is like the most important part of the
If
year.
there's one thing you guys take from this, it's vesting. It's like number one, vesting.
And 83B.
Yeah, 83B.
It's like crazy important.
Okay, so voting rights and vetoes, another issue that needs to be picked up early on in your organizational documents. Again, it's going to think this through. How many founders do you have? What are their equity interests? Is majority voting the right choice? Should it be supermajority? What are there veto rights? Again, picked up in the shareholders agreement or in the operating agreement. Buy, sell, or other impasse provisions, especially when you have two founders, 50-50 interests. Really think this one through and get it right, because this, I've seen companies fail over this. When you have 50-50 decision making, the two reach an impasse. They don't have a device for breaking an impasse or a buy-sell provision, and it can be a very sorry end for what would otherwise be a successful company. There are different ways to handle this. You can have a shotgun buy-sell, which is kind of the grown-up version of, you divide, I choose. One person sets the price to buy or sell, and the other person decides whether they're going to buy or sell at that price. You can designate a third party to act as a decision maker when to decide between the two conflicting viewpoints. There are various ways to handle this, but it's important to get some kind of mechanism in at the beginning, because once there's a dispute, then it's hard to sort it out after the fact.
Paul, just a dispute or death. So if one of the founders dies, right, whoever is receiving their share of that equity, you then become a partner with them. And it could be a spouse, it could be a estranged child, it could be whoever. So you really want to have the buy-sell in place to protect you from a dispute or death.
Transfer restrictions, this comes up different ways, but think about, again, your co-founders. Are there going to be restrictions on them selling their equity? You may decide that there's a blackout period for a certain period of years. So for the first 2 years, no one can sell their equity. Obviously, you can all agree among yourselves to waive that, but you may want something like that written into the agreement. You probably want rights of first refusal. So if at some point people have a right to sell, the company at least, and maybe the other stockholders have a right to buy. And then rights to compel or participate in an exit, drag-along rights. Well, let's say you have 4 co-founders. You may decide that if 3 of you agree that you want to sell the company, the 4th has to go along. So you can't have one shareholder holdout for a deal that everyone generally regards as a good deal. Now, for 4 people, you may decide, well, we all have to go along. But suppose you have more smaller shareholders. You want to have an ability to drag those people along in the sale so that they can't hold out and prevent the company from a good exit. The flip of that is tag-along rights. If the big dogs have the ability to get out of the company to sell their interest, then the smaller shareholders should have a right to go along with it.
By the way, these things get complex. Like, in the last year, you start to see provisions like, based on the Me Too movement, if someone's accused of sexually predatory activity at even a small company, that might be a triggering event to be able to, buy them out or do other things. So you can get pretty creative. And I was just going to say, a lot of people turn to think about how the myriad of ways this can all work out. They go to the National Venture Capital Association website, the nvca.org website, and look at some of their template forms, which are used around financings, and they kind of they're annotated in a way that describes some of these provisions. So I'd encourage you to, if you're interested in this area, because it's pretty user-friendly, nvca.org forms.
All right, we have 2 more slides. So just say a word about the initial issuance of the equity. Again, it's going to be common stock in the case of a corporation or membership interest in an LLC. The founders are always going to get common stock or basic membership interests. As the company grows and as you bring in investors, there will be other classes of stock, other series of stock or membership interests layered on. So investors will get preferred equity. If you have employees, you may want to give them, often we'll set up LLCs, so we'll have a separate class of profits interests sometimes, maybe without voting rights for employees. I mean, there are all sorts of ways that you can create different classes and different series of equity as you go along, as the entity grows. But in the first instance, it's going to be common stock for the corporation or membership interest for the LLC. In the next session on financing, we will talk about all those nuances, valuation, class, preference, dilution, and other things that need to be considered with respect to financing. Also, as I noted in the third bullet, at the time of formation, usually any IP that has been created pre-formation gets assigned into the entity in exchange for the equity. And that is something that we will talk about further in the third session, at least the third legal session, about protection of intellectual property. Last thing to mention is just to say a word about initial funding, which we've already touched on a little bit here. Generally, in the beginning, it's going to be the founders that are going to provide the initial funding. It is generally contributed pro rata, although it need not be. If it is not contributed pro rata, then you need to figure out how that is going to be managed. So one founder is putting in, perhaps one founder is putting in all of the, or most of the money, and the other 2 founders are putting in a limited amount of money. Is that additional money going to come in on a promissory note? Is it going to be a convertible note? Maybe it comes in over time, and there's an increase in the percentage equity interests for the founder that's putting in more money. There are any number of ways to handle it, but be savvy to the point that if the money is not coming in pro rata, you do need to figure out how you need to manage that and figure out how that's going to be handled as between the co-founders and the company.
Paul, I don't know if you do this, but sometimes when I'm in this situation, to avoid that complexity, the wealthy person, say it's 1/3, 1/3, 2 people put in $100 and the other puts in like 15,000, and they still keep it 1/3, but they treat it as additional paid-in capital, and as a result, that means their tax basis for their stock is just much higher. So at the end of the day, if they sell it, right, they're starting from a higher basis. So that's another way, in theory, to do it. The reason that might make sense is that the truth is, founders owing a company money, investors, let's say with a promissory note, the investors come in and they say, wait a minute, I'm not going to pay you back that. That's sort of, as far as I'm concerned, you're a founder. Your value is in your equity. So they sometimes force them to do exactly, like forgive that debt, and it gets contributed to the company and becomes additional paid-in capital anyway.
Right. And that's the exact experience I have. And a lot of times founders will put money into the company, and then an investor will come in and they'll say, oh, well, we're getting, $2 million. I'm going to get all that money that I put in back, right? And I'll say, no, that was that's just the name of the game, right?
And your value is in your equity, and you basically paid to make that equity be worth more.
And even evidencing it as a promissory, I mean, the investors will say that's cute, but no, we're not going to pay that back because that's what the deal is as a founder. Sometimes a convertible note will get respected, or a safe will get respected, and they'll let that converted roll into the preferred, because at the end of the day, usually that's part of the pre-money anyway, so they don't care. But ultimately, you know, you need to be thoughtful about that and know that there's a strong likelihood it will just be paid in capital. I'm not going to get that money back.
So, but the takeaway here is, and that's absolutely right, and founders will often think, well, yeah, money's coming in, do I get my money out? And the answer is almost 100% never. So if the money came in pro rata, then it doesn't matter so much. If it doesn't, then you've got, you know, an unhappy co-founder who feels like they're not getting full value. You know, so there are various ways to handle it. Chris mentioned one. I'm going to, securities law compliance, I'm just going to mention, whenever you issue equity interests in your corporation, you do need to make sure you are in compliance with the securities laws. That counts as sales to employees, advisors, investors, friends and family, your landlord. You know, there are all sorts of, you know, consultant. There are all sorts of situations where you start giving people equity because that's all you got, because you got no cash. And that's okay, but do it right. Make sure you're complying with the law. There are relatively easy exemptions for issuing equity in an early stage corporation, but you got to know which exemption you're using, and you got to make sure you comply with it. And if you do that, then you're probably fine. If you don't have an exemption, if you don't comply with it, and you're trying to clean it up later, heaven help you, because sometimes you can't clean it up after the fact. And if you can, it may be really expensive to do it. And we're talking about civil and criminal penalties for violations of the securities laws. So, you know, word to the wise, consult a lawyer before offering equity. And again, this topic will be addressed in more detail in our next session, which will be in late April on financing. So that's it for this evening. Thank you to Kris, to Helen, to Michael. Let's have a big round of applause. I think we'll all be around for a little while to answer any questions we didn't get to. If you want to get on the mailing list, if you want to get a copy of the PowerPoint, make sure you give me your business card. Have a good night.
And there's plenty of wine and refreshments outside. So
Yeah, drink more.